So good news for Abby Martin. She sued the Georgia State University. I think that's the name of it, Georgia State. And they basically penalized her for not signing a contract, which they get everybody to sign, which is that you basically have to pledge a lifetime support in a way for Israel. Basically, you're not allowed to engage in any boycott, divestments and sanctions of Israel. That's what they were trying to get Abby Martin to sign. And she was due to, at that time, do a talk on the media at this university. And they basically said, unless you sign that contract, you cannot do that. She was actually going to get paid for that as well. And that outright goes against the First Amendment rights, actually, of freedom of speech. And that should be protected, that you should be able to boycott any country or any organization, really, if you wish to. That is a protected right.
Statement by Abby Martin on federal court victory striking down Georgia's anti-BDS law. By Abby Martin. I'm thrilled at the judge's decision to strike down this law that so clearly violates the free speech rights of myself and so many others in Georgia. My First Amendment rights were restricted on behalf of a foreign government, which flies in the face of the principles of freedom and democracy. The government of Israel has pushed state legislatures to enact these laws only because they know that sympathy and support for the population they brutalize, occupy, ethnically cleanse, and subject to apartheid is finally growing in popular consciousness. They want to hold back the tide of justice by preemptively restricting the right of American citizens to peacefully take a stand against their crimes. As the world watches, Israeli aggression continues in Jerusalem, the West Bank, and against the population it besieges in Gaza. It has never been more urgent to advance the boycott, divestments, and sanctions movement against the Israeli regime. The striking of this law is a necessary and timely opening to build this urgent task.
And so what the Georgia State University, I think was it Southern Georgia State University, basically insisting that you can't actually work for that university unless you sign basically a pledge to Israel, that you cannot boycott them. Well, that's outrageous. Imagine if in Alabama that the all black men were told that you couldn't boycott the Montgomery bus system there. That basically you had to pledge allegiance to the state of Alabama and not boycott the Montgomery bus systems. So, that would be outrageous. Imagine if someone said to you, well, you can't work at this university unless you pledge allegiance to Russia, that you cannot boycott Russia and you cannot criticize Russia ever in your life. And unless you sign the contract, you can't work for that university or for the state. I mean, it's outrageous. Imagine if they said, unless you pledge to never ever boycott Saudi Arabia, then you pledge to not boycott them for life, and you do that in this contract, then you can never work for this university or this organization or whatever. It's outrageous. So anyway, that's what Abby Martin refused to sign, and then she took the university to court, and they won. Abby Martin won. So, of course, they're going to appeal that. So this is a really important landmark decision for the BDS movement, the boycott, divestments and sanctions movement. And it's outrageous and it's not surprising, though, in this kind of, where the US is a failed state, and it's run by the oligarchy, and it's run by corporations. US imperialism is very tied to Israel. Israel does US imperialist proxy wars in the Middle East. And then in return, the US gives them $10 million in military aid every day. $10 million in military aid every day. So it's a symbiotic relationship that the US has with its very close ally, the nuclear-powered ethno-supremacist regime that is Israel. So that is why the US is so closely tied to Israel, because Israel does its proxy wars. So unless we are addressing US imperialism and trying to bring an end to US imperialism, the oppression and genocide of Palestinians will continue. Anyway, I wanted to show you this discussion between a few lawyers. One of them is a few of them are from CAIR, C-A-I-R, and then there's Abby Martin's lawyer. And it's an interesting discussion. I might just take snippets out of it, but they were discussing the victory by Abby Martin over, basically, as Abby put on her Twitter thing, it's basically over Netanyahu. So anyway, this is an interesting discussion, and hopefully the appeals will fail. They expect that they will. CAIR expects that they will fail. So because it's totally unconstitutional, but like the US has the 14 defining characteristics of fascism, so who knows really? I mean, I'm never surprised what happens really in the US anymore, because the rule of law doesn't seem to apply. It applies in some circumstances when it comes to corporations, but it doesn't apply, to the rest of us on many occasions, and particularly to black and brown people there. So anyway, stay tuned for this. Thanks for watching.
Brothers and sisters, may peace be upon you. Assalamu alaikum. This is Edward Ahmed Mitchell welcoming you to a special program today. As you know, we would normally have our CAIR on Air programs on Tuesday and Thursday, but we're having a special program today because something very special happened today. And we're very happy to share this information with you, answer your questions, and discuss next steps. So as some of you may know, CAIR and our partners at the Partnership for Civil Justice Fund and CAIR Georgia just won a huge victory in a federal district court in Atlanta. We're going to bring on now our special guest to tell you all about this important victory and what it means not only for the client, the person involved, but also potentially for all Americans. So let's bring on all of our guests now. We're going to have Mara Varhillian-Hilliard of the Partnership for Civil Justice Fund, Murtaza Khwaja, the Executive Director of CAIR Georgia, and Justin Sadowski of CAIR National. All of them have played an important role in this case. And without further ado, I'm going to turn it over to Mara to tell us a bit about the case. And then we'll go to Justin and then Murtaza.
Good afternoon, everyone, and thank you so much, Edward. And I just want to say what a great joy it is to reach today, and what a pleasure it's been to co-counsel and litigate along with CAIR litigators on this case, which is really a crucial case in the United States for First Amendment free speech rights. Our client, Abby Martin, whom some may be familiar with, many may be familiar with, is an award-winning journalist and filmmaker, and her work includes the documentary film Gaza Fights for Freedom. And she had been invited to speak at Georgia Southern University. In fact, she had been asked to be a keynote speaker, the keynote speaker, at a conference on critical media studies, critical media information. And as part of that process, she was sent a contract to sign, and the contract reflected Georgia's newly enacted anti-BDS law, a law that the Georgia state legislature put into place explicitly targeting the political viewpoint of those who support the boycott, divest, sanctions movement, which is a peaceful movement challenging the conduct and crimes of the Israeli government against the people of Palestine. That contract actually directed Abby Martin that she was to renounce her support for the BDS movement, that she had to swear that she would not support the BDS movement in order to be able to receive the contract to speak at this conference. Now, of course, Abby Martin, who is an extraordinary person of conscience, she has devoted her life to fighting for justice, and saw this and wrote back saying, well, of course I cannot sign this. And what ended up happening is that she was disinvited from this conference. The conference was canceled because she could not and would not sign this. She spoke with us, and we all agreed that we wanted to wage this fight on behalf of Abby, but on behalf of everybody in Georgia, for their free speech rights, for your right to think whatever you want to think, to engage in the political activity that you believe in, to not have the government or legislators turn and tell anyone what you may or may not think, or punish you for your beliefs. And of course, this is even more extraordinary because here you have government officials, state legislators in Georgia, in the United States of America, directing American citizens what they may or may not think or do with regard to a foreign country, actually really requiring people to, in essence, take an oath with regard to a foreign country. So extraordinarily dangerous. And all around the United States, there has been a concerted effort to enact these kinds of anti-BDS laws in order to silence, suppress, punish the movement of people who are peacefully seeking justice for the Palestinian people, and who are very concerned that our government, that the government of the United States, is providing the very weapons, is providing the support that we could see in use over these last weeks in the onslaught against Palestinians. And so this is a crucial moment in time, too, because so many people around the United States, so many people now are standing up, questioning the government, questioning as taxpayers, what is our taxpayer funds going to? Is this the policy of the United States that we support? And historically, boycotts have been essential in American history in moving the social justice movement forward. They have been essential when you look back at the Montgomery bus boycott and the actions of the civil rights movement to demand an end to Jim Crow apartheid throughout the South. They were essential with regard to the farm workers and other labor organizers in having boycotts to advance, for example, the right of farm workers to organize in the vineyards and in picking grapes. So we believe that this moment in time and this ruling is so crucial, and really applaud it, because we need this as the American people. We have to always have the right to say what we think, to fight for what we believe in, to not be threatened by a state for punishment for those beliefs. And just because some state legislators may not agree with any particular political opinion or point of view, they do not have the right to try and legislate it away. And that's what this ruling says today, that the First Amendment, the due process, that our rights to free speech are protected under the Constitution explicitly when it comes to peaceful, non-violent boycott activity, and that the government may not tell us that we can't engage in that or associate with others or support it.
Absolutely, absolutely. Thank you so much for that excellent summary. So for me, and I think Mortez as well, we've been aware of this law since 2016. It was first passed back in 2016. And it took, 4 years before it was finally implemented in a way that allowed us to challenge it. Morteza, both as our executive director and as our legal director before that, and as our staff attorney before that, has been deeply involved in working on Capitol Hill, dealing with legislators, the very legislators who passed this law. Morteza, can you give us a little background on the law when it was passed, Stacey Abrams' position on it, and then recent attempts to change the law to try to save it from being overturned? And then we'll go to Justin and talk about what the actual ruling today was.
Absolutely. Thank you for that, Edward. Assalamu alaikum to everyone, all the viewers. So this law was first introduced in 2016. Back in 2016, then House Minority Leader at the Georgia State House, Stacey Abrams, led the opposition against this bill because she saw, as many of us do, the fundamental necessity of having and protecting the right to Georgians' free speech and boycott. The Democratic caucus, voted against it unanimously, but the bill in a Republican-led legislature did pass. It went strictly on party lines. And since then, we had not had any plaintiff who had standing until this Abby Martin case. Once we did file the lawsuit, however, there was an amendment proposed during the legislative session about a year ago, which tried to change the amount that would trigger the provision in the contract saying that you would not boycott the state of Israel to being $100,000 versus what it is now, $1,000. And this was at the behest of Israeli foreign officials. I was sitting in committee meeting the day it was introduced to the committee, and the representative who had authored the amendment gestured to the back of the committee room and said, I was asked by Israeli foreign officials who are here to change the amount. And we've seen this, and I'm sure Mara and Justin can attest to this in other states, where they've tried to change the amount that the contract is worth before the provision kicks in to avoid the law itself being overturned. Because alhamdulillah, I think as we've seen from today's decision, which is a big first step, is that this is protected speech. This is that's been unconstitutionally prohibited. And so we should see a positive resolution, inshallah, in favor of our plaintiff. But what this amendment was attempting to do was to avoid the law itself being overturned. Last session, it didn't move forward. However, this year's session, it was introduced again by a bipartisan group of legislators. And while there was some opposition to the case, both members of both parties voted almost unanimously for it. There was some opposition that was led, but there were a lot of other voting efforts that were going on. So this bill was able to move forward, where they changed the amount that the contract provision would be kicked in to $100,000. Similarly, there was another amendment proposed that would actually repeal the bill in its entirety. So many of the Democratic caucus and many Republicans who actually are not in favor of this law voted for the amendment because it would restrict the number of people that it would actually affect and the number of people's rights it would actually affect. However, our position and the position of State Representative Becky Evans, who authored the full repeal of this law, is that any form of restriction of this protest is unconstitutional. To give you an extreme analogy, if you prohibited all Black males to vote, that's clearly wrong and unconstitutional. It would not be better to say all Black men over 70 cannot vote. That is still unconstitutional. And just because it restricts the number of people it affects does not mean it's a law that you should pass. So what we're really hoping to see next session is a repeal of the law in its entirety, which we still have 2 years of this session, or 1 year of this 2-year session in place. So the repeal bill is still introduced. It has not been voted on, and that can, inshallah, move forward next session.
Thank you, Morris, for that background and the update. And I think the victory today that we experienced, and Justin will tell us about that now, really helps a lot, because the court ruling that we got from Judge Cohen pointed out that not only is this illegal, unconstitutional apply to Abby Martin, but also that it's inherently flawed, that you are restricting speech specifically for the benefit of the Israeli government, and specifically political speech. And so even if you change the amount of money so it's not impacting a certain person, you still have a law in the books that says you can boycott every country in the world, including your own government, the American government, but you can't boycott one particular foreign country. It's the very definition of favoring one form of political speech over the other. Let me take it to Justin now with no further delay, and tell us what's the good news. What was the result of what's the good news from this ruling today?
So we argued, and the court agreed, that there are 3 different reasons that this law violated the First Amendment of the U.S. Constitution. The first is that it violated the right to boycott. By barring people who boycott Israel in their personal or in corporate capacity, depending on who it is, they are taking away the rights of those people to engage in protected speech, which is a boycott. That's been the NAACP versus Claiborne Hardware case has declared that to be a right since the 1970s. I don't have the date of that. I apologize for saying that I did. There was another case involving, I don't know if any activists here remember, a case called Rumsfeld v. Fair that involved a situation where colleges weren't allowing the military on base because the military didn't meet their anti-discrimination clause. And the court said there was no First Amendment issues at play there. And the states have been arguing that meant you did not have a right to boycott, but that case doesn't use the phrase boycott. And the only district court that has ever found that Fair and not Claiborne applies, and therefore tried to uphold the law, was in Arkansas. And while the district court found the law was constitutional, the Eighth Circuit, a very conservative circuit, in a opinion with the panel had 2 Republicans and a Democrat, they overturned the district court's decision. One of the Republicans dissented, but one of the Republicans and the Democrat both voted to overturn that. So there's no decision that hasn't been overturned that has found any of these laws constitutional. And these things tend to build off each other. So it was our work on behalf of Bahi Amawi in Texas, along with the work of ACLU lawyers in Arizona and Arkansas that helped lead to this moment. And those are decisions that the court cites. The other 2 reasons this law was found unconstitutional, and all these laws are found unconstitutional for the same reasons. One is because it compels speech. It doesn't work they don't do investigations of people to see if you boycott Israel. You have to sign something that swears you don't boycott Israel. And that's forced speech. You have to it's basically a loyalty oath to Israel. And that's, the courts have, as I said, consistently found that inappropriate. So that's unconstitutional for a second reason. And then a third reason they found it unconstitutional is because it's vague. And this is a more complicated issue, but they're trying to bar people from not doing business with Israel for BDS reasons, but they can't bar people from signing contracts just because you don't do business for Israel, because lots of people don't do business with Israel for, all sorts of reasons other than boycott reasons. You might not know anybody.
Economic reasons, or just whatever.
Yeah. The Israeli company that you might work with is too expensive, and so you went with the German company or the local company, or you just might support localism, so you went with the local company. There's all sorts of reasons. And in order to make this constitution, they can't go out and say, because you oppose Israel's human rights records or because you support Palestinian records. So they use this vague language for non-business reasons, but it's intentionally vague to protect it from being declared unconstitutional for other reasons, but it doesn't save it, because you can't be vague on things that can avoid speech, because people need to know when their potential speech is being chilled. So for all three reasons, again, building on prior decisions, the court ruled that the law is unconstitutional. Now, it was a motion to dismiss. So the important part about this is the court has not enjoined the law at this point. The court has just said, even if all the facts in the complaint are true, it would violate the law, but hasn't ruled on the facts of the truth. That being said, the facts in the complaint in this case are not controverted, right? There's not really there's not really an argument that no, Abby Martin really doesn't boycott Israel or she wasn't going to enter into a contract. So the lawyers have to get together and figure out how to turn this into a final judgment, but that's the next step.
Gotcha. Well, that brings my next question, Samara. So back to you now. Number one, Abby's reaction to this, and what's the next step? I mean, this is an important victory. The case itself is not over. I mean, there are a few different issues. One is, for example, what damages if indeed the facts are uncontroverted going forward, and the final ruling is in our favor. What damages would go to Abby, if any? What's the remedy in terms of the law? The law has been changed now, and so does the law still fall? So there are all sorts of things that have to be worked out. But what's Abby's reaction right now? And in terms of next steps to combat not only this law but other laws around the country, what are you thinking?
Well, this is so important at this particular moment, as we were talking about, because so many people in the United States are really turning and looking. Many people who haven't understood or really, heard about the struggle in Palestine, and for many folks in the U.S. who, the same way that last year, became deeply involved in the racial justice movement, who maybe for them previously hadn't been, but now, because of what they're seeing in the world, they are thinking, how do I get involved? What can I do? And here you have the BDS movement, which is, offering one of many mechanisms for people to become involved, become engaged in the struggle. So the lawsuit is impactful, as you've talked about, and as we're all talking about, because of the breadth that goes beyond the immediacy of just obviously Abby Martin. And although the court didn't strike the law, as you said, the posture that we were in at this moment was not seeking the preliminary injunction. We had filed a complaint, and this is the process where then they moved to dismiss, and the court denied that motion to dismiss. So obviously the next stage will be looking at basically striking the law in full. And obviously that will have its own life, either with the court doing it or perhaps the government now making the decision that it needs to rescind its unlawful, unconstitutional law. I mean, there's no question about this law. There's no question that it's completely infirm. It is not savable. It's not like a little piece of it is okay, but the rest of it can stand. I mean, this is a fully and totally unconstitutional, illegal law. Now, interestingly enough, the court did issue a ruling with regard to qualified immunity. And that issue on qualified immunity, which is something that, many of us who litigate civil rights matters all around the United States and police misconduct matters are dealing with constantly, because it's this artificial construct that provides individual immunity, generally from damages, to officials or police who commit unlawful, unconstitutional acts, and in police misconduct cases, acts of violence, killing people, and then are somehow immune from personal liability with this very contorted logic that if the exact same incident had not occurred previously, then they couldn't have been on notice that doing what they did was unlawful. And the law has expanded its breadth to such an extent of absurdity that courts are looking for absolute particularity. Now, of course, here, we believe that Claiborne Hardware was very clear about the lawful nature of boycotts, and that, in fact, boycotts are protected First Amendment activity. We don't think that was unclear, and we believe that all of these officials had to be clearly on notice as to the nature and state of First Amendment law and constitutional rights and due process in this regard. So we would disagree with that part of it. Of course, the other question here is whether or not the attorneys for Georgia, for the state, would seek to appeal this. And we don't know that yet. We don't know whether they would seek to appeal this to the 11th Circuit. We believe that we are absolutely correct in our argument. We believe that the judge is absolutely correct in his determination that this law is illegal and unconstitutional. But we will know soon what the next steps are in this case.
Absolutely. And I'll tell you, when I was in law school, I had the pleasure of actually interning with the State Attorney General's office. Really great people who work there, also people I disagree with. I'm pretty sure they're going to appeal this unless they think that the change in the law that they've made will somehow allow them to evade responsibility and that there's no need to fight it. But I suspect otherwise, given the Attorney General, who that is, and the politics, that they'll probably appeal. But I'm also confident that we'll win again, God willing, because as you just said, Mar, I mean, the law is clear, and it's been clear in every other state that has looked at this. Arkansas most recently, Arizona, Texas. One of my favorite parts of the ruling today is that at one point, the Judge Cohen notes that the state argued that, well, look, in Arkansas, their anti-BDS law was upheld. That was the argument that the state of Georgia made. But after they made that argument, the appeals court in Arkansas ruled the lower court ruling was wrong, and their law was unconstitutional. And so the Judge Cohen noted that fact as well. So every court that looks at this just about comes to the same conclusion. I mean, as we said at our press conference a year ago, if you could ban or require Abby Martin to sign a loyalty oath to a foreign government saying she's not going to boycott them, then that would mean that Alabama could have forced black people to sign an oath saying that if you want to work for the state, you can't participate in the Montgomery bus boycott. And we would all recognize that as inherently wrong, but also unconstitutional, right? And so anyway, so we are confident in victory here, but this is what lawyers are for. This is what civil rights work is for. So the struggle continues, God willing. So it's about 3:30, so we're going to wrap up now. Mara, I want to thank you so much. Please send our appreciation to Abby as well. We hope we'll get to talk to her soon, God willing. Justin, thank you so much for the great work you and the legal team did on this case. And Mortaza, thank you so much for your leadership as well in working on this case. A great victory for all involved, not just for Abby, not just for organizations, not just for the Constitution, but for every American. I think we just got a little bit closer to having their right to boycott protected wherever they are, whatever job they're doing for the state or with the state. So thank you all so much.